So the big story this morning is, of course, the South African government welcoming a court ruling out of Malawi recommending Pastor Shepherd Bhusiri and Mary Bushiri's extraditions to South Africa. The pair face multiple criminal charges in South Africa. They fled the country while out on bail. The self-proclaimed prophet at the time raised fears of his life and was worried about receiving a fair trial. South Africa submitted an extradition application request to Malawi seeking their return to stand trial on various charges, including rape, violating bail conditions, as well as financial crimes. The Justice Department says it has been informed that the pair intends to appeal this latest ruling. For more on this, let's now bring in Thabo, Chakaka-Nyirenda, who is the Attorney General for the Republic of Malawi. A very good morning to you, Attorney General, and thank you so much for making time for us this morning. I want to start off with your reaction as the Office of the Attorney General with regards to the decision that has been taken by the court.
In simple terms, I think you may know that a lot of the Attorney General in this case is neutral, but of course what we say is that because we operate on the rule of law, therefore that we welcome the decision from the court. That is the short response I can make. And of course, in view, of course, of our international obligations, the agreements that we signed with the Republic of South Africa, we think that the courts are able to implement those agreements.
Yeah. So then in terms of the extradition treaties and considering the charges and some of the charges that have fallen away, what does this then mean for the Bushiris who are extradited? Will they only face the current charges, which amongst them include rape, fraud, forgery, as well as skipping bail? I just need some clarity around this because the court had said that with the 13 charges that have been brought before the court, it's only 3 of them, 4 in the case of Shepherd Bhusiri, that actually meets the requirements for extradition.
Yeah, I think we still more will be operating under the international principles and the agreements. So under the principle of speciality in international law, especially in extradition matters, that means that the charges that have been brought cannot be prosecuted in South Africa unless with the consent of the country and the consent of Mr. Shepherd Bhusiri. So that's for short. And unless and until, of course, the state appeals, counter appeals on those charges that have been dropped. But I understand some of the charges have been dropped by the state. Some of them, of course, I think it's ruling by the court. The court noted that they could not be sustainable. But it means that, therefore, that it's only those charges that have been sustained are subject to this prosecution, the extradition that will form as a basis for prosecution if the prosecution proceeds in the Republic of South Africa, as I said earlier on, under the international principle of speciality.
Yeah. Just quickly explain to us what you just meant now by consent.
What that means that once the extradition is done, therefore that if South Africa intends to prosecute on other charges, apart from those charges that don't contain, they are not part of the extradition, the South African government will have to seek the consent of the Malawi government to prosecute on those charges. Of course, it also may extend the consent from Mr. Bushiri. Of course, you have to fight in court to say the extradition is only with respect to these 3 or 4 charges. You cannot prosecute me on the other charges. So therefore, that at that stage, if the South African government wants to prosecute Mr. Prophet Shepherd Bhusiri on other charges, including those that have been dropped, it will require the consent of the Republic of Malawi.
Okay. Then there's the matter then goes to appeal, as already been indicated by Prophet Bhusiri in a statement that was shared on Facebook. I understand that his attorneys had already indicated as well to the court that they will be appealing this particular matter. Does the court, the High Court, then have the powers to say that, sure, the lower court dealt with some of these matters, but we believe that there's actually a stronger case to bring back some of the charges that have fallen away after the deliberations by the lower court? Or would it solely just be on these 3 or 4 charges?
So it also depends on what will be before the High Court. So as I indicated earlier on, if there is a cross appeal by the state, then the court will have to deal with those matters that the state has cross-appealed. In this case, the state, together with South African government, understand that the prosecution was also, the extradition was prosecuted alongside some state lawyers from South Africa and together with lawyers in Malawi. Of course, at the same time, Mr. Shepherd Bhusiri had lawyers from South Africa in Malawi. It's allowed for a lawyer that practices elsewhere to specifically get an admission for a specific case. So it also depends on what the lawyers are going to do. If they want to cross-appeal, they'll make cross-appeal. Then the High Court may say that prosecution can proceed on even other charges or can also sustain the appeal. But you should also know that the High Court is not the final court, appellate court. There'll be two-tier appeal processes, because the highest court is the Supreme Court. So whichever way the judgment will come, the either party may have to appeal to the Supreme Court. But the appeal to the Supreme Court will only be on limited grounds only on matters of law. If they'll have to identify errors of law only, not matters of facts. And then the other thing is that before the appeal will now proceed to the Supreme Court, there'll be another process of seeking leave to appeal. In short, leave to appeal means a permission to appeal. So this will be, I think, the thing that will also be actually should be considered in this case. So it's not only an appeal that will go to the High Court, there is also a potential appeal to the Supreme Court, but that also depends on the outcome of the case. So whichever part that would be aggrieved by the decision of the High Court will have to go to the Supreme Court. Of course, we don't expect these processes to delay because in the other processes, we had to have issues of preliminary applications and also hearing of evidence from witnesses, examination and submissions. In this case, there will only be one hearing, and that's the hearing will appear in the High Court. And even if there's an appeal in the Supreme Court, there's only going to be only one hearing in the Supreme Court.
All right. AG, please stay with us. We just need to take a quick ad break. When we come back, we're going to continue the conversation and also want to understand what the role of the Attorney General is when it comes to extradition according to the Malawian law. Stay tuned. This is Channel 405. We're taking a quick ad break. We'll continue with that conversation after that. Welcome back. We continue our conversation with Thabo Chakaka-Nyirenda, who is the Attorney General for the Republic of Malawi. And this is following a court decision in one of the courts in Malawi for the foundation that has been laid for the extradition of Shepherd Bhusiri as well as his wife Mary to come and face criminal charges back here in South Africa. AG, thank you so much for your indulgence and to continue making time for us this morning. The Bushiris have also indicated that they will be appealing this matter at the High Court. But one of the things that was raised in the lower court was around whether they get incarcerated immediately or whether there will be a bail application. And understand that the bail application will now be made before the High Court. Can you just explain to us what that process entails?
So I understand that the bail application from the Costa Court has already been granted. What that entails that if there is another process, of course, to do the same process, the bail application can still go to the High Court. But as of the report that I got yesterday, is that Mr. Bushiri is no longer incarcerated, is out on bail. I think he was able to conduct his services after the court appearance. So what that entails is a bail until bail pending appeal. It's not something that is unusual in the sense that Mr. Bushiri, though he's a fugitive, is still, Prophet Shepherd Bhusiri still remains innocent under our Constitution, in particular Section 42 of the Constitution. He remains innocent until proven guilty in the court of law. So, as I said, that what that will mean that he will remain on bail until the appeal process is finalized in the High Court. The High Court can decide whether the bail should be revoked or not. And then they can also be under further process as well on the same issues of bail to the Supreme Court, depending on the outcome of the case. I understand that as of now, of course, maybe it might also be very difficult for the state to say he cannot be granted bail in the sense that some of the fundamental principles in terms of granting bail are whether a suspect, in this case, has connections outside the country. So he may say that he doesn't have any connection or any access outside the country. Of course, we know the only connection is South Africa, where he fled. So I think that's why perhaps there was, what I'm told the word that was used was a stay of implementation of the decision of the Magistrate Court, which directed that Mr. Bushiri should remain incarcerated until the process of the process of extradition is finalized.
All right. And just focusing now on the High Court appeal, do you have any idea how long that could take before a decision is taken by the High Court? We're told that the matter would be heard within 30 days. I
think I wouldn't predict how long the process will take in this case. But what I know for sure is that the timelines for delivery of judgments, once the hearing is done, if indeed the hearing takes place within 30 days, the court act requires that the judgment be delivered within 3 months. So the maximum period for which we can wait for the judgment will be 90 days. But otherwise, of course, that doesn't mean that the judgment should be delivered at the end of the, before 90 days, immediately before 90 days, but it can be delivered within 10 days or 30 days or 60 days. But the maximum period is 90 days for which the judgment can be delivered under our statutes.
All right. And then quickly explain to us what the role of the Attorney General would then be if there is finality on the extradition, and let's say, hypothetically speaking, that South Africa is successful in its application and is successful in defending the appeal.
Yeah, in explaining the role of Attorney General, I don't want to venture into the merits of the appeal or the merits of the case, but
sure.
What you should know that the law starts from the time the request for extradition is made. So the Attorney General under our statute, and I should also believe that in other countries, I know that South Africa doesn't have an Attorney General, is the central authority in handling requests for extradition, processing them and ensuring that the requests themselves, they comply with the relevant statutes, in this case Malawi, and then of course the international obligations or other treaties. And then following the Attorney General is designated central authority. Now, following in a court ruling whether the person should be extradited or not, the Attorney General actually now processes final documents that the fugitive offender be extradited to any country. So in this case, we are talking about South Africa. So therefore, the other thing that the Attorney General coordinates with other law enforcement agencies, in this case, the Director of Public Prosecutions, and also the police, the Minister of Foreign Affairs, and then the other side, the equivalent of the Attorney General, the other side, of course, through the diplomatic channels, particularly the embassies and Minister of Foreign Affairs, to ensure that the processes are carried through. And then, of course, even though the courts operate independently, after the order is made, the Attorney General coordinates with the courts to ensure that his court's decision is implemented. So that's how I can briefly explain the role of the Attorney General. So in this particular case, those documents were processed through my office, and I signed certain documents. Also people signing documents, including documents that didn't come from South Africa that are supposed to be submitted to the court. Yeah.
Would you then have to satisfy yourself as well that the accused in this matter will be safe, that their safety is guaranteed?
Yes, that is the requirement under our statutes. And the other requirements under our statutes is that the trial is not politically motivated at the safety of the accused person. And then, of course, that the prosecution is not also based on racism. And so these are the things that I say that the role is to ensure that that request conforms with our laws, firstly, that's municipal law, and then secondly, with the international laws, international treaties, also conventions are complied with. So once the office, my office, myself satisfies myself that there is nothing like a violation of the statutes of the international obligations of treaties, then the processes start and the case is met in court.
All right. Is there anything in the Malawi law that allows law enforcement and the Attorney General to say that while the court has made a recommendation or the court has said that a country has met the requirements for extradition, but on the basis of new information that has come to the fore to the law enforcement as well as the Attorney General's office, therefore the extradition will not happen?
So in this particular case, because that will be a court order, but also the person should be extradited. For that to happen, there's need also for another court order. So if there's new information that will come to the fore, then an application will have to be made to the court that this extradition will not be done. As I said, that now the duty, once the court order is made, the duty is to implement the court order. Otherwise, the content of court issues will arise. So if one wants to not to comply with the court order, the step that has to be taken is to make an application for variation of the court order. And then, of course, maybe also making an application to have that order revoked. So,
all right.
As I said, that obligation that is placed on the Attorney General is there throughout, even after the court judgment. But now, in that case, the law will be limited, and the only thing is to go back to the very same court that issued the order, that this court order will not be implemented. But in this particular case, immediately after the ruling is made that the order should have, or the judgment should have been implemented, but that the fugitive offenders, that is Thabo Bushiri and his wife, Shepherd Bhusiri and his wife, had to make an application for suspension of the implementation of the law, and of course that is within the law, because of course under the Constitution one has a right to access the court, even the highest court. In this case, that's okay. So as a constitutional right, and then of course we also needed to respect his constitutional rights that of access to the court. So in short, there's only limited recourse in this case to say we can't comply with the court order.
Okay.
We have to comply with the court order once it's granted.